Hi everyone, my name is Nivan and I'll be doing the debrief for the law facts topic, the round 4 prepare topic, which reads, this house believes that developing countries should pursue investment agreements that require state-to-state arbitrations compared to agreements which grant foreign investors standing to sue governments in investor-state arbitrations. But before that, I just want to do something very quickly, and that is I would like to begin by acknowledging the Ngunnawal and Ngambri people, the traditional custodians of the land that I am recording this on, and I pay my respects to their elders past, present, and emerging, and extend that respect to any Aboriginal and Torres Strait Islander people. This always was and always will be Aboriginal land, and sovereignty was never ceded. With that being said, I would like to get in on the proposition's case. The first thing that I want to point out here, and I don't think this is limited to just this debate, but specifically topics which are extremely specky and require that are kind of complex, and it isn't intuitive, as where the day-to-day person oftentimes doesn't have interactions with these kinds of topics. I think it requires a significant amount of setup from both the proposition and the opposition. And specifically, Prop 1, I think, requires a lot of setup. With that being said, I think the first speaker on Prop does need to spend a good chunk of their speech doing a significant amount of this setup. But what do I mean as to what the setup requires? What is required for setup. So I think the first thing that you want to point out here is that the context in which investor state arbitration started taking place was post World War II, where there was a big movement of free market economics and economic liberalization. And that kind of thinking and that kind of laissez-faire approach what has underpinned the court, these kinds of investor state arbitration court system since then. So that is the kind of framework you want to paint these systems to be, a system of very free market and very prone to economic liberal values, which are oftentimes values that are better for big multinational companies that have the resources to thrive in a free market system. The second thing you want to point out here is when you first prove the idea of economic liberalization, you want to point out that a lot of the system of the court is very pro-business friendly, and a lot of the individuals in this apparatus, specifically the judges who are appointed, oftentimes come from that similar kind of area where they're very pro business and try to have that kind of same kind of thinking process. That's what you want to set up first, and then you also want to set up the idea that this is where the company directly sues the nation. There isn't third parties involved. It is the investor and the state, and the investor appoints one judge, the state appoints another judge, and the judges that the investor and the state has appointed, those two come together and appoint a third judge. So you want to first characterize what those investor state arbitrations look like. The second thing that you want to do here is also characterize what state to state arbitrations look like. So the big differentiation here being that MNCs need to convince their home country, that is the country that they're from, to sue the host country, which is the developing country that they're suing. So they need to have that convincing power. And you want to, in setup, kind of get to the idea where it is very hard, even for big companies, to, you know, get big nations like the US, China, and Canada to really sue these nations. And there are a couple of reasons, right? So there are geopolitical reasons. For example, there's a strategic relationship that you have with this particular nation. Maybe it's on a specific, sea line, or that it's very close to an enemy that you possibly have. The second thing is you want to prevent, perceptions of yourself as being, neo-colonial, or that you're seen as a bully, as bullying developing countries. And you also don't want to lose control to other countries, specifically countries which are seen as, battlegrounds where, there's a significant amount of American, Chinese, Indian, or European, Canadian, Japanese influence. You don't want to do these kinds of things and lose that kind of connections you have with those states. But the second thing you could also point out here is also political consequences. It is very hard for like the US to stick its neck out for big companies, because that could lead to domestic repercussions, because some of these companies are not perceived to be the most ethical or the most seen not the most ethical, but also not seen as, the best companies to be in bed with as politicians. So you have those reasons why. And the last thing you want to focus when it comes to state-to-state arbitration is that it's a tool of last resort. And oftentimes diplomacy and coming to a diplomatic solution is oftentimes the first thing. And oftentimes then you want to characterize what diplomacy looks like. It's more of a bargain between two nations. So you're more likely to get more favorable terms in that sense. The last two things you want to do in setup is characterize what MNCs look like. So big multinational companies like Philip Morris, Chevron, lots of resources, lots of legal knowledge in this particular sphere, whereas developing states oftentimes do not have the resources to do these kinds of things and lack the technical know-how. So technical knows how to operate in these kinds of court systems, how to, really convince those judges in a particular way. So it is kind of like this cards are stacked against developing countries. In terms of the first argument, I think the first argument is pretty straightforward, and you want to focus on why why focusing on state-to-state arbitration better helps economic development in developing countries. So the first thing you want to point out here is, again, you have those incentives, incentives of why developed countries are unlikely, developed states are unlikely to sue developing states. You have those reasons, but you also have like other economic reasons as well. So, do you really want like a country which has an abundance of natural resources? Are you really willing to go and sue that nation and make it much harder for potential other companies in that particular region to do business and extract those natural resources, or factories or supply chains that are particularly important that are coming from those nations? Would developed nations want to jeopardize those things? But the last thing you also want to point out here is the norm of equality. So in the international realm, oftentimes there's a perception of equality, and developing countries often has given that level footing through things such as WTO dispute resolution mechanisms, which kind of gives them more wiggle room than in investor state disputes. And then this is really important because insofar developing states are given that wiggle room and given that level of freedom that you won't get under the investor state systems, this allows developing nations to do things freely and pass things such as social protection laws and health laws. And the best example of this is when Philip Morris intervened in Uruguay to prevent smoking related regulations. And this would happen on investor state system. Whereas, you know, conversely, would the American government, during the height of the Cold War, mind you, really jeopardize that relationship with the Uruguayan government over, smoking regulations? Probably not, right? So because of those things, you're able to kind of better pass laws and better pass things that suit your people far better. But the second thing you could also say under this particular point is that it prevents regulatory chill. And that is, developing countries, you don't even need to sue developing countries, but rather the threat of suing is enough for developing countries to not even pass basic social security laws. Like, for example, you need to have clean rivers in Argentina, or you need to, have basic regulations regarding like child protection in places like the Democratic Republic of Congo. The second thing you want to point out on his argument is the quantity of things. So it is, considering it is just the corporation suing a nation, it is far easier for them to do that comparatively to them going to convince a government and then the government taking actions. It is far easier for them to do it by themselves, and this means possibly you being sued as a developing country far more, and this is particularly harmful in two key ways. The first thing is that means your legal costs and the amount of time you spend in legal courts is far higher, and also it means that you would possibly have to put up more money in terms of settlement. And I think this is particularly important because if a lot of your resources are bogged down in the, legal court systems and legal bearings, this could potentially give a very bad appetite to other investors because they see you constantly being sued. Would they really want to invest in another nation like that? And I'll come back to this point later on. The third thing you want to point out here is that when it comes to state arbitration, it is oftentimes a lot more transparent and a lot more clear. Oftentimes, the WTO is where you should go to settle these kinds of disputes, and oftentimes the WTO mechanism is clear and transparent. Comparatively, the ISDS system, there is no need for transparency, and developing countries could, engage in really bad practices, or they could really be, steamrolled by like big multinational companies in this particular instance. The second argument I think is quite an interesting one, and I think this is where the idea of investment comes into play, because you want to preempt the big opposition push, which is on the environment. So the two things I would like to point out here. Right, but before that, I would like to bring about the idea about you being bogged down, you constantly being sued is bad for perception of a nation, and that could also potentially deter investment. So that has that kind of cross applicability across the two arguments. The first thing I want to point out here is that MNCs who use ISDS are likely to use this to protect themselves. So you want to say that the only reason as to why you want a specific apparatus that is very pro business is when multinational companies are like, okay, we want to do something kind of shady, and we don't want other people. We want a system where they're more likely to get decisions in their favor, so they don't really have an incentive to cooperate and build connections in developing country. Rather, they want to go in, extract as much rent as possible, and kind of leave the country. But comparatively, in a state-to-state arbitration system where it is unsure whether the government is actually going to save you or not, you are much more inclined to actually be kinder to the government officials, be actually care about long-term investment, long-term growth, because you're going to be in that country for a long period of time. The second thing you could point out here is that oftentimes, because of the regulatory chill and the regulation changes that multinational companies want under the ISDS system, this would actually deter investment, because what multinational companies look for when they invest in a country is policy consistency. So different kinds of agreements that you enter under ISDS could possibly mean that policy consistency would not happen, and thereby your ability to have that kind of policy consistency where the regulations are clear, it's easy to invest, is more likely to happen on your side than on ops world. So that's the government case. Let's talk about the opposition's case. And I think there are two pieces of framing that are important for op here. And I think the first thing here is that there is a significant power imbalance between multinational companies and big developed nations. That is to say, the United States government or the British government is far more powerful than Land Rover or Chevron, and they have the ability to inflict far more damage on you as a nation than a company can. The second thing you want to point out in context is that developing nations currently they have high levels of unemployment and significant resource constraints. So when it comes to the budget, accounts of all kinds of things that they're resource constrained. So they have a dire need for foreign direct investment. With that being said, the first argument I think a pretty basic one in the sense that why this attracts FDI. The first thing you want to point out here is that it provides legal protection, right? So the context you want to point out here is that developing countries' courts oftentimes may not be the most business friendly. Oftentimes, because of colonialism and the anti-colonial aspects of these nations, they often took a very socialist trend. So because of that socialist trend, they often have huge legal protections for labor, huge legal protections, for the environment and those other kinds of things. And it's kind of a very unfair and a very not business friendly environment. So in the ISDS system, you can enter into contracts which are far more business friendly, and you're more likely to get that kind of legal protection in this ISDS system rather than in the local court system. And that kind of, no you're very much aware, and then you have that kind of assurance that your intellectual property, your investments are going to be good or going to be protected. You have that kind of assurance, which means you're more likely to invest. The second thing you want to point out here is that oftentimes then you also can't join trade agreements because ISDS is baked into a lot of trading agreements across the globe. So if you don't have this system, that possibly means you'll be not being able to join trade agreements, which could possibly mean that your ability to build export markets as a developing nation possibly reduce, and that could have impacts on, for example, foreign exchange and jobs and things like that. The second thing that you want to point out here is that when it comes to state, it's far worse because when states do things, you can point out that states do things far worse. So, they could really cut down on aid they give to you. They could make it really hard for you to trade with other nation states. They could, vote against you in the UN, or they could really mess you up in the international scheme, and that could potentially lead you to really, really bad things. So even if the states sue, if multinational companies convince big governments to sue developing nation state, even if they win or lose, they still have the capacity to harm you particularly badly. So that could potentially be something that you do not want and prefer to, it basically means pick your poison, right? Do you pick the poison with the multinational company, or do you pick your poison with the big state that has a lot of political capital in the world and can really screw you over, right? And then you could kind of give you some incentives as to why it's likely to occur. So, for example, like big corporations can do things like lobbying, or they, have prominence in a prominent industry. So, the mineral industry in Australia, oil industry in the US, or the automobile industry in the EU. All these are massive companies who have a lot of political influence, and they are able to really convince states to go after developing nations. The last thing you want to point out here is that why this is actually good for developing countries' policy. And the biggest thing you can say here is that ISDS promotes policy stability because you have outdated laws in developing nations. These actually brings them up to, more modern systems, and therefore that kind of policy stability is particularly important because that means that you have more modern laws and modern systems coming into play, and which could potentially steamroll a lot of the old archaic laws developing countries have. So you're able to double down on the investment systems, which is far better for your country. So that is my two piece. Hopefully that was informative, and yeah.